Good morning, everyone. I hereby call to order this 11th meeting of the Pennsylvania Public Utility Commission for the year 2022, and I ask that everyone please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. As a reminder, at today's meeting, it is open to the public and the commission will act on various matters, but there's no opportunity for the public to address the commission at this public meeting. The public meeting motions, statements, and video will be available on the commission's website later today. So as our first first item to consider is the minutes for August 4th, 2022, and I will call upon Vice Chairman Coleman, who is the editor.
Well, thank you, Chairman. I have reviewed the minutes of the August 4th, 2022 public meeting and move that they be approved as submitted.
You have heard the motion to approve the minutes. Is there a second?
Second.
Any discussion on the minutes or further edits? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The minutes are adopted, 3-0. And now we will call on our Secretary of the Commission, Rosemary Chiavetta, who will lead us through today's agenda.
Good morning, Madam Chairman. Good morning, Commissioners. Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1 with matters presented by Director Monahan and the Bureau of Audits. It is recommended that the Commission adopt in an omnibus motion all 3 items on page 1, beginning with the Universal Service Program audit for the People's Gas Company, LLC, and ending with the Generation Supply Service Rate audit for the Wellsboro Electric Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 2, in matters presented by Director Sophie and the Office of Special Assistance, it is recommended that the Commission adopt in an omnibus motion the single item on page 2, the formal complaint of Armstrong Telecommunications versus Verizon, Pennsylvania et al., and continuing the omnibus at the top of page 3 to include and end the omnibus with the formal complaint of Dwayne Ackey et al. Versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 3-0.
Continuing at the bottom of page 3, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of the Bureau of Investigation and Enforcement versus Verde Energy, USA.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? I do have comments, and I ask that my comments be spread upon a record as if I read them in their entirety. I think I finally got it. I mean, it's been 8 years, right? I finally got that. But I will not read them in their entirety. The Bureau of Investigation and Enforcement filed a formal complaint on January 30th, 2020, alleging that Verde Energy USA, Inc. engaged in slamming and deceptive sales practices, resulting in nearly 9,000 violations of the Commission's energy marketing regulations. As a relief, I&E requested a civil penalty of $8.8 million, revocation of Verde's license, and customer refunds. The OCA filed a timely notice of intervention on February 24, 2020. On January 21, 2022, the ALJ issued an initial decision approving the settlement between I&E and Verde. Before us today for review and consideration are the exceptions filed by the OCA opposing the ALJ's initial decision. My comments today, consistent with my comments made at the October 7, 2021 public meeting, focus on the intervention filed by the OCA in this case, specifically the manner in which the statutory advocate was and was not permitted to participate in the proceeding. Of note, I&E and Verde developed the stipulated facts relied upon by the initial decision, as well as the non-unanimous settlement, without the participation of OCA. Those stipulated facts were verified by counsel and not by witnesses because no witnesses were presented by either party in this case. The OCA was not allowed the opportunity to present additional facts or evidence to be heard regarding the OCA's objections to the non-unanimous settlement. In fact, the OCA was not permitted to present a witness in this case. The OCA was also not permitted to cross-examine any witnesses regarding the stipulated facts or the settlement. No open evidentiary record was created in this proceeding. It is true that this commission has a policy favoring settlements. However, the commission's duty to make decisions based on the substantial evidence and in furtherance of the public interest cannot become a victim of the procedural efficiency afforded by the settlement. The process used in this case to facilitate the settlement prevented the OCA, the statutory advocate charged with representing the interests of the very residential consumers victimized by Verde's actions, from fully participating in this proceeding. While the settlement before us provides for refunds and much-needed controls over or on Verde's sales practices, I believe that because the OCA was not afforded due process, it is not possible to state affirmatively that the evidentiary record in this case is complete or that substantial evidence has been presented to support the settlement. And for these reasons, I will be voting no. Any further discussion on this matter?
Chairman, I do have a couple of comments I'd like to add to the record this morning.
Vice Chairman Coleman.
Thank you. I guess my first comment is that I hope that this is the last of these significant issues with suppliers in Pennsylvania. This market is well beyond mature, and that the suppliers that are operating in this space need to make sure that they're following the rules of engagement. Unfortunately, this one has now been sitting with us for over 2 years. But again, I hope that the supplier community pays heed to this. This hopefully will be the final warning on unacceptable behavior in a competitive marketplace. The other concern I have this morning is that, as the chairman indicated, that there are 300 plus customers that are on the other end of this complaint that have been waiting for their remedy. And we're sitting here this morning, in my opinion, with a process dispute between this commission and the Office of Consumer Advocate, and I think that's unfortunate. I believe that customers deserve their refunds. They have been aggrieved in a process, and we're, again, over 2 years beyond that infraction. And unfortunately, customers are still waiting. And the company, Verde, has still not been held to the standards that we look for in suppliers. So for the last 2 years, as we have struggled with a process dispute, Verde has still yet to receive the judgment of this commission, and I find that to be a bit unfortunate. The only parties to this case are our Bureau of Investigation Enforcement and Verde, and I think that's important to understand. If the OCA felt that there was something in this proceeding that they found objectionable to, they simply could have filed their own complaint, and would suggest if they still feel that they are aggrieved, that's the remedy here. Holding customers hostage in this process is unfortunate, and they deserve better. And so I am glad that we have this item on our agenda this morning and hope that that will bring this to conclusion. I want to thank our Bureau of Investigation Enforcement, and I want to thank Judge Pell. I think they have done a yeoman's job in bringing this matter before the commission. I think that the $1 million civil penalty against the company and a contribution to the PPL hardship fund of $75,000 is appropriate. I also continue to believe that the OCA was afforded adequate due process in this case. The OCA had sufficient time to conduct discovery over a 6-month period. The OCA was also invited to participate in the settlement discussions and declined to do so. The OCA filed a detailed statement in opposition of the settlement and advocated its position at a pre-hearing conference and submitted written comments. So this was before the judge, and the judge did take this into consideration. The OCA's objections speak to its preference for how the case should have been evolved and the preference to expand the scope of the proceeding beyond the I&E's formal complaint. And again, I would just emphasize that if that's the sentiment of OCA, then OCA should have filed its own complaint. Such preferences do not constitute a violation of due process. I reemphasize what we stated in our order on interlocutory review and what the chairman has just mentioned, that the OCA is free to file its own complaint and to address the additional allegations as they wish. I believe that it's in the interest of the affected customers to finally receive the refunds that are agreed by the parties in 2020. So hopefully this will be the end of this proceeding and that Verdi gets a clear message and that the customers that have been affected by this bad behavior are finally going to receive the remedy that is due to them. Thank you.
Thank you very much, Vice Chairman Coleman. Any further discussion? Hearing none. All those in favor, please say aye.
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 Any opposed? I'm voting in the negative. The motion passes 2 to 1, noting my dissent.
Turning to page 4, it is recommended in an omnibus motion that the Commission adopt both items on page 4, beginning with the formal complaint of Lawrence Kingsley versus PPL Electric Utilities, and continuing the omnibus to include both items on page 5, ending the omnibus with the formal complaint of Lily Hirsch versus UGI Utilities.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3 to 0.
Turning to page 6, it is recommended that consistent with 4 PA Code, Section 1.43C, the notational vote of the Commission regarding the petition for reconsideration in the formal complaint of Patricia Wasserman versus PPL Electric Utilities be recorded and entered in the minutes of this public meeting.
Is there a motion to record the notational vote on this matter?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3 to 0.
Continuing at the bottom of page 6, it is recommended that the Commission adopt in an omnibus motion the formal complaint of Amanda Polk versus the West Penn Power Company, and continuing the omnibus to include both items on page 7, both items on page 8, and both items on page 9, ending the omnibus with the application of Liani's Transportation, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3 to 0.
Turning to page 10, and matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt in an omnibus motion both items on page 10, beginning with the tentative order canceling the licenses of certain electric generation suppliers, and continuing the omnibus to include all 3 items on page 11 and all 3 items on page 12, ending the omnibus with the letter of notification filed by the PECO Energy Company Electric Division.
Is Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 13, in matters presented by Chief Counsel Hicks and the Law Bureau, it is recommended that the Commission adopt both items on page 13, beginning with the petition for rescission filed by Reliable Power Alternative Corporation, and ending the omnibus with the petition for reconsideration filed by Mary Ellen Donahue, doing business as Avalon Energy Consultants.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. And any opposed? The motion passes 3-0.
Turning to page 14, it is recommended that the Commission adopt the proposed order in the application filed by the Pennsylvania American Water Company Wastewater Division to acquire the assets of Foster Township in Luzerne County.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion?
Yes, Madam Chair, I have a motion on the matter.
Commissioner Unora.
I ask that my motion be entered in the record as if I read it in its entirety. Before the Commission is the petition filed by Pennsylvania American Water Company. The petition seeks reconsideration of our July 14, 2022 order granting the application for the company to acquire certain wastewater assets from Foster Township and offer associated services. I agree with the company that ordering paragraph 2 of the July 14th order could have been modified to require the filing of Act 537 plan and to establish the Foster Township pretreatment program and discharge ordinance as a condition closing rather than as a condition to obtaining a certificate of public convenience. This is a type of flexibility that is consistent with our 3.501 proposed rulemaking order, which includes amendments to streamline some requirements for established utilities during the process of acquisitions of other water and wastewater service providers. However, as the certificate of public convenience has already been issued in this matter, the issue is now moot. I also agree with the company that ordering paragraph 10 of the July 14th order must be modified to clarify that the company has already filed a base rate case that includes the assets of this acquisition. Ordering paragraph 10 should apply to the company's first base rate case that proposes to include the assets of this acquisition and the rate base rather than in the next base rate case that should not include the requirement of further testimony to be filed. Therefore, I move that, 1, the petition of expedited reconsideration filed by Pennsylvania American Water Company is granted in part and denied in part, consistent with this motion. And 2, that the Law Bureau prepare an opinion and order consistent with this motion. Thank you.
Thank you, Commissioner Unora. You've heard the motion. Is there a second?
Second.
Second by Vice Chairman Coleman. Any discussion on the motion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0. Is there any objection to taking the previous roll call on the matter as amended? Hearing no objection, the matter as amended passes 3-0.
Turning to page 15, and matters presented by Administrative Law Judge Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt the recommended decision of ALJ Cheskis and ALJ Chiodo in the proposed rate case and joint settlement of UGI Utilities Gas Division.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? I do have an item that I asked to be submitted into the record in its entirety, and I will actually read the whole thing because it's not long. Before the Commission for consideration and disposition is the settlement to UGI Utilities, Inc., Gas Division, proposed rate increase. Included in the settlement is a Weather Normalization Adjustment Pilot, or WNA. UGI recovers a significant portion of its fixed costs utilizing volumetric rates. Such fixed costs do not vary with the amount of gas delivered to customers. The weather normalization adjustment here is designed to recover distribution revenues needed to satisfy the cost of service requirements determined in this proceeding, while mitigating the variance between actual and projected revenue due to weather. This decoupling of uncontrollable weather from revenue should stabilize UGI's cash flow and in turn allow UGI to focus on operational items within its control, namely infrastructure upgrades and repair. Further, since this decoupling mechanism is only applied to the distribution component of the bill and not to the natural gas commodity charge, incentives for efficient consumption are maintained. While noting such positives associated with the weather normalization adjustment, I also emphasize that design and administration of such mechanisms can come with challenges. I encourage UGI to closely monitor the effect the WNA has on its customers' bills to ensure it does not result in any significant rate shock. Any further discussion or comments on this matter? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Madam Chairman, that concludes regular agenda. Turning now to the carry-in agenda, on page 1 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed order extending the waiver of regulations regarding service requirements to the Secretary of the Commission.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Madam Chairman and Commissioners, that concludes all items to be considered today.
Thank you very much, Madam Secretary. Before we do close, I would like to make some comments for the record. This week, September 12th through September 16th, the PUC recognizes the Lifeline Awareness Week in collaboration with NARUC's national effort to increase public awareness about programs that assist eligible Pennsylvanians to stay connected through the Lifeline program. Lifeline helps to ensure that eligible Pennsylvania consumers have access to affordable voice and broadband communication services needed for employment, telemedicine, telework, and online learning. Lifeline is a federal government benefit that provides eligible consumers a monthly discount on their phone and internet bill. The benefit can be used for voice, broadband, internet access service, or a combined telephone internet service product from a landline or wireless provider. The program provides a $7.25 per household per month discount on landline or wireless voice service and a $9.25 per household per month discount on your wireless or landline internet service. To qualify, consumers need to be at or below 135% of the federal poverty guidelines or participate in specific federal programs like the Veterans Survival or the Federal Lunch Program. Now is also an appropriate time to remind consumers that the Affordable Connectivity Program, or ACP, is available to them. The ACP provides eligible households with discounts of $30 a month for the purchase of broadband service or up to $100 to purchase equipment needed for internet service. As part of our efforts, more information on program eligibility for both the Lifeline and the ACP, as well as how to apply, is available on the Commission's website, and information brochures are also prepared by our staff. So we wanted to recognize Lifeline Awareness Week. And we have nothing else to come before us, so if there's no objection, I will entertain a motion to adjourn.
So moved.
Second.
Second. Motion by Vice Chairman Coleman, second by Commissioner Yenora. I'm assuming there's no discussion. All those in favor of adjourning, please say aye.
Aye.
Aye. Any noes? Passes 3-0. We are adjourned.